एक चीज केवल हम ये नहीं समझ पा रहे हैं कि पार्ट जजमेंट को हम लोग चैलेंज किए, एक सेट के साथ तो कंप्रोमाइज हो, दूसरा सेट के अगेंस्ट में किए, उसके अगेंस्ट में काउज ऑफ एक्शन भी प्लेट में कोर्ट का लैंडेड फर्स्ट अपील कोर्ट का फाइंडिंग हम, और उन लोग अपीलेट स्टेज में एक खतियान को प्रोड्यूस किए कि भाई हम लोग खतियानी रहे थे, उसको उनका कर दिया। केवल हम एक एग्जामिन कर लेते हैं कि उनके अगेंस्ट में
कुछ नहीं, अभी बोल ही रहे थे कि कुछ नहीं ऐसे
कुछ
है ही नहीं आपके केस में।
तो एक चीज केवल यही है, हम इसलिए
एक आर्गुमेंट तो खड़े हुए थे, एक आर्गुमेंट तो रिकॉर्ड कराइएगा करें।
तो वही हम तो स्पष्ट बता दिए।
नहीं, आप तो फेयर हैं, आपको सुनते भी हैं, एक डेढ़ घंटा भी सुनते हैं।
कल तो 2 घंटा माय लॉर्ड,
2 घंटा ऐसा सुनने में कोई कमी नहीं है।
कमी नहीं, इसलिए हम बोले बिना फाइल ओपन किए कहे कि एक से के साथ तो कंप्रोमाइज कर लिए, अब बचा केवल पार्ट में उनके अगेंस्ट में फाइंडिंग है कि प्लेट
खतियानी रैयत का ही वो डिसीजन।
हाँ, खतियानी रैयत, लेकिन खाली एक चीज है कि केवल खतियान के बेसिस पे उसका
नहीं, आपने बोला था कि सत्यवती का है प्रॉपर्टी, लेकिन आपने उसका ना खतियान प्रोड्यूस किया, ना कोई डॉक्यूमेंट, कुछ भी नहीं प्रोड्यूस किया।
रिटर्न भी बोलते हैं,
कुछ नहीं प्रोड्यूस किया, कोई डॉक्यूमेंट नहीं।
हालांकि तो परचेजर है रजिस्टर्ड डीड से,
तो क्या हुआ? लेकिन आप जब बोल रहे हैं कि खतियानी रैयत है, या मान लीजिए खतियान से ड्रॉ कर रहे हैं कोई चीज, तो डॉक्यूमेंट तो प्रोड्यूस करना पड़ेगा।
केवल एक एग्जाम इस पर्पस से कि केवल खतियान के बेसिस पर, उसके बाद अगर मान लीजिए कभी दखल में रहा ही नहीं,
एडवर्स पोजीशन का केस नहीं बनाया,
उसके अगेंस्ट में बोलते हैं कि कोई काउज ऑफ एक्शन ही प्लेट में नहीं बोल, मतलब हम अपने अगेंस्ट में बोल रहे हैं।
हाँ, समझ रहे हैं, कोई काउज ऑफ एक्शन
नहीं है। तो एक चीज इसलिए हम केवल देखना चाह रहे हैं कि अगर काउज ऑफ एक्शन उसके अगेंस्ट में बनेगा, तो हम अगर बनेगा तो हम
ये हमको क्या ही बोलना है, आप पोजीशन में हैं।
हाँ, हम तो पोजीशन में हैं।
तो जब आपको कोई हटाने आएगा तो आप अपना एडवर्स पोजीशन क्लेम करिएगा, क्या दिक्कत है?
इसीलिए तो
हम कुछ दिखाएंगे तो
नहीं, हम ये नहीं
लॉ विल परमिट यू, आई एम नोबडी टू परमिट यू इन सेकंड अपील।
तो है
कोई परमिशन हमारा
परमिशन अगर लॉ देता है तो देता है,
नहीं देता है। एक भी ऑब्जर्वेशन इधर उधर बहुत दिक्कत,
तो हम वही सोच रहे थे कि क्या हम विड्रॉ कर ले इस लिबर्टी से, लेकिन चूंकि हम ये एकदम वेरी फेयर इसलिए बोले कि चूंकि गांव का क्लाइंट लोग है तो हम
नहीं
करते भी नहीं,
ये इंस्ट्रक्शन नहीं है विड्रॉ करने की।
हाँ, हमने तो बुलवा करके एक बार सोचे कि
नहीं, बुलवाना क्या है
कि एक सेकंड अपील का अगर फाइंडिंग आ जाएगा उसके अगेंस्ट में,
फाइंडिंग क्या, हम तो बोलेंगे कोई सब्सटेंशियल क्वेश्चन ऑफ लॉ नहीं है, क्या फाइंडिंग है? अभी तो क्या ही मर्ज होगा इसमें, मर्जर तो नहीं होगा ना, कुछ नहीं होगा, देयर इज नो सब्सटेंशियल क्वेश्चन ऑफ लॉ,
वही करके खत्म।
देखिए सेकंड अपील नंबर 70 of 2021 for the learned counsel appealing on behalf of the appellant. This appeal has been filed against the judgment and decree dated 7/7/2021 with the bracket decree signed on 19/7/21 bracket close, passed by the District Judge Roman 6 Chatra, whereby civil appeal number 12 of 2018 has been allowed in part, and the judgment and decree dated 26/3/2018 within bracket decree signed on 3/4/2018 bracket close, passed by learned civil judge within bracket senior division bracket close 1 Chatra in original suit number 13 of 2012 has been set aside. The learned counsel for the appellant has submitted that there was a compromise with before the first appellate court
with the appellate number 1
with
to
the
6.
appellant number 1 to 6.
Yes.
Namely, Shrimati Sabita Devi, Vijay Saw, Vinod Saw, Ajay Saw, Munna Saw, and Anil Saw. And therefore, the appeal was disposed of in terms of the compromise in connection with respect to the land in Khata number 6, Kesra number 180, area 1.04 acres. The compromise petition dated 6/7/2021 was allowed, and therefore the appeal was only restricted to the other property, that is khata number 40, Khesra number 185. Correct? The learned counsel for the appellant, by assailing the impugned judgment, has submitted that
Para 26.
the first appellate court has allowed the appeal primarily on the basis of additional evidence.
Only on the basis of Khatiyar Exhibit E and not a single document.
Only on the basis of cadastral Khatiyar Exhibit E, which was running in the name of Sohrai Mali and sister of defendant number 8 and 9, and no further document was produced on behalf of the defendant. The learned counsel has submitted that the Khatiyar was produced by way of additional evidence before the learned first appellate court, है ना?
Yes.
Which is apparent from paragraph number
paragraph 22.
which is apparent from paragraph number 22 of the first appellate court's judgment. The learned counsel submits that a substantial question of law be formulated and decided.
The only ground I have raised, my lord, that the learned first appellate court has not examined anything which is evident from paragraph 26. Only in one paragraph saying the case of the defendant, and nothing has been examined in order to appreciate the case of the plaintiff and the defendant. Finally, see paragraph 26.
पहला 11 से तो पूरा ही एग्जामिनेशन
हाँ देखा लिखा जाए वो केवल और केवल उससे के संबंध में है.
The learned counsel for the appellant has also submitted that the learned first appellate court has not considered the case in totality, and primarily the case has been decided on the basis of exhibit E. After hearing the learned counsel for the appellant, this court finds that the plaintiffs had filed the suit for declaration of right title and interest over the suit land described in Schedule 1 and 2 of the plaint, and also sought confirmation of possession, and if found dispossessed, for restoration of possession after evicting the defendants. The case of the plaintiff was that the suit land was owned by one Satyavati alias Savitri Devi, who executed power of attorney in favor of one Dr. Naresh Chandra, who in turn executed SAT number 7137 in favor of Kedar Yadav for land of khata number 6, plot number 180, area 18 Disney, and SAT number 7140 in favor of one Lalita Devi for land under khata number 6, plot number 180, area 52 Disney. And thereafter, Kedar Yadav and Lalita Devi executed SAT number 3491 dated 7/5/2010 in favor of plaintiff number 1 for land under khata number 6, plot number 180, area 68 decimal. The same plaintiff number 1 also purchased 72 decimal of land of khata number 6, plot number 180, area 50 decimal, and 10 decimal of land of khata number 42, plot number 183, area 2 decimal of plot number 183, and 10 decimal of plot number 182 from Dr. Nagesh Chandra Singh, while registered SAT number 7141 dated 23/12/2008 on the basis of genuine power of attorney executed by executed in favor of Naresh Chandra Singh by Savita Devi. It was their further case that plaintiff number 2, Shattanvi Devi, purchased 88 decimal of land of khata number 40, plot number 185 by JD number 143 from Naresh Chandra Singh on the basis of general power of attorney. And it was also pleaded that all the purchasers came in possession of the suit property and the land was mutated in their name. It was their further case that one Ashok Kumar, who had no right, title and interest over the suit property, and one Hari Sao executed an illegal sale in favor of defendant number 2, Srimati Savita Devi, with respect to an area of 1.25 acres appertaining to khata number 6, plot number 180, area 1.04 decimal, and khata number 51, plot number 107, area 21 decimal, on the basis of illegal power of attorney, alleged to be executed by Ashok Kumar in favor of Hari Sao with respect to the suit land. And thereafter, the defendants have been illegally claiming right, title, interest and possession with respect to the suit property. The cause of action arose on 22/3/2012 when the defendant took attempt to dispossess the plaintiff and ultimately the suit was filed. A joint written statement was filed by defendant number 1 to 7, denying the case of the plaintiffs and also denying that there was no cause of action and that the suit was barred by limitation, and also claimed adverse possession. The suit was hit by its specific fact. It was the case of the defendants that Ashok Kumar got a registered power of attorney dated 3/2/1989 from Srimati Satyavati Devi, alias Savitri Devi, with respect to khata number 6, plot number 180, area 2.04 acres, and khata number 51, plot number 107, area 1.21 acres. And thereafter, Ashok Kumar Singh executed power of attorney dated 5/2/2009 in favor of Hari Sao before notary public, getting permission from Satyavati Devi with respect to the land in question. And on the basis of this power of attorney, Hari Sao executed JD number 1321 in favor of Savita Devi for total 1.25 acres under khata number 6, plot number 180, and khata number 51, plot number 107. After purchase, defendant number 2, Savita Devi, applied for mutation, and her name was mutated and she was paying rent to the government. The plaintiff had no right, title and interest in possession with respect to the suit, with respect to the property purchased by defendant number 2, Savitri Devi. There was another joint written statement of defendant number 14 and 15, and it was pleaded that the plaintiffs were not in possession of the suit property. It was further pleaded that the land of khata number 6, plot number 180, area 2.04 acres was recorded as Gair Madhiwa Khas land of ex-landlord of village Lone Singh Kala named Babu Viren Visheshwar Singh. The defendant number 14, Kameshwar Mali, was the second heir of the land measuring area 25 decimal out of 2.04 acres of land of khata number 6, plot number 180, on oral permission of ex-landlord Babu Visheshwar Singh. And in Samvat 2001, issued hukumnama in favor of Kameshwar Mali for the land measuring 25 decimal out of 2.04 acres of land of khata number 6, plot number 180, and for land measuring 50 decimal out of 64 decimal of land of khata number 19, plot number 172, and accordingly issued zamindari rent receipts in his favor. The defendant number 14 and 15 were own brothers who were enjoined cultivating possession of the second land, and defendant number 14 was recognized as Rayat, and demand register was opened in his name. They were paying rent to the government, and they had also amicably partitioned this land. It was also pleaded that Khata number 40, plot number 185 of village Dosi was recorded in the name of one Sorai Malik, who was a grandfather of these defendants, and it is continuing in possession of these defendants, and that the plaintiffs had got no cause of action. So far as defendant number 8 to 13 and 16 and 19 are concerned, 16 to 19 are concerned, they did not appear, and the suit was ex parte against them. The following issues were framed by the learned trial court. Both the parties were oral and documentary evidence. The learned trial court discussed the materials on record, and while considering issue number 6 and 7, and considered issue number 6 and 7 together. And held that and observed that in common law, two separate standard of proof are recognized: proof beyond reasonable doubt and proof based on the balance of probabilities. And while considering the civil suit, the balance of probabilities is to be considered. The court held that the plaintiffs had successfully established his title and possession over the plaintiffs had successfully established their title and possession over the suit land, and they were entitled for declaration of title. And ultimately, the issues were decided. Both the issues were decided in favor of the plaintiffs. Internal page 19, the trial court judgment. Mark that this would have. The issue number 1 and 2 were decided in favor of the plaintiffs, and issue number 3, 4 and 5 were recorded as not pressed. And ultimately the suit was decreed on contest against defendant number 1 to 7 and 14 to 15, and ex parte against the remaining defendants. The operative portion of the judgment of the learned trial court is as under: ordered. So far as the learned first appellate court is concerned,
प्लेंटिफ का टाइटल डिक्लेयर नहीं हुआ था.
sorry,
लास्ट पैराग्राफ लास्ट पेज में है, उसमें इट इज मेड क्लियर दैट द प्लेंटिफ्स हैव नो राइट टाइटल इन इंटरेस्ट ऑन खाता नंबर 51 प्लॉट नंबर इतना पीरियड 21.
the learned trial court held that the plaintiffs had no right, title and interest over land of खाता number 51, plot number 107, area 21 decimal, right?
यस
यही प्रॉपर्टी
हाँ,
है इसमें.
नहीं मतलब इसके बाद और भी था, इसमें बोल दिया कि आपका कुछ नहीं है, इसके आगे इसमें अपील नहीं किया आपने, ठीक.
ठीक है. So far as the learned first appellate court is concerned, point for determination कहाँ है? The sole point for determination was framed in paragraph 14, that is, whether the plaintiffs have title and possession over खाता number 40, case number 185.
Para 25 is irrelevant for 7.
Sorry?
Para 25.
The fact remains that with respect to the property in खाता number 6, case number 180, area 1.04 acres, there was a compromise and there was no occasion for the learned first appellate court to go into the and the learned first appellate court had disposed of the matter in terms of compromise with respect to the same property. At the first appellate stage, additional evidence was led and
पैरा 19
additional evidence was led and defendant number 14 and 15 who were applicant number 7 and 8 produced Khatyan of land of khata number 40, plot number 185, which was marked exhibit E, and in paragraph 22 of the judgment it has been recorded that it was running in the name of Sonai Mali, son of Gokul Mali.
The court has also taken into consideration that not a single line about 7 and 8 they have written in the plan. That is in page 25. Page para 25.
The learned
The middle manner.
just
Plaintiff in his plan has not attached a single line about the respondent number 7 and 8.
the learned first appellate court also took into consideration that the plaintiff in the plaint had not stated a single line about the respondent number 7 and 8 who were defendant number 14 and 15 in the trial court. So, in the pleading, no case of the plaintiff with regard to these defendant number 14 and 15 was made out. The finding of the learned first appellate court has been recorded in the learned court also took into consideration the fact that the plaintiff witness in his cross-examination had stated that in the survey Khatyan, he saw that the Khatyan was recorded in the name of Satyavati Devi. Although at the first appellate stage the Khatyan was exhibited and as additional evidence with respect to khata number 40, plot number 185, exhibit E, which stood recorded in the name of Sonai Mali, son of Gokul Mali. Ultimately, the learned first appellate court recorded the finding in paragraph number 25 and 26 as under. This court finds that the learned first appellate court has rightly considered the materials on record, including the pleadings of the respective parties and also the additional evidence which was brought on record at the first appellate stage, that is exhibit E, whereby the property was recorded in cadastral Khatyan, exhibit E, in the name of the in the name of Sonai Mali, son of Gokul Mali, who was admittedly the ancestor of defendant number 14 and 15. 14, 15 ke the ancestor, right? Considering the totality of facts and circumstances of this case, This court is of the considered view that no substantial question of law is involved in this case, which is accordingly dismissed.
Great.
I have filed a caveat in the, my name may be.
एवियन का क्या करें?
सर जी के सर का
I have
नाम
filed a
है
caveat, otherwise I would not have said.
ठीक है, आपका अपीयरेंस रिकॉर्ड करें।
हाँ, मेरा caveat है इसमें. That's why I'm asking.
ऊपर ही लिखा है। The
Otherwise,
the-
order 41
the
rule
respondent
is also
has entered appearance through caveat. And the learned counsel for the respondent is present in the court. However, for the court, बस इतना ही काम
आ गया सर का नाम
प्लीज पूरा बनना चाहिए चलिए
DPO.
But filing for Kalapana, we also have some.
oh yes certainly
To the clients.
certainly
Otherwise, they will say you are not appeared.
हाँ ठीक है
Item
और थोड़ा तो
31
आप हमको असिस्ट कर ही दिए ऐसा तो नहीं
I did my duty.
Item 31